Welcome to Gov Square Live. I'm Anna Medvinskaia and this is Fred Philpott. Today we will be discussing the Consumer Protection from Unfair Trading Regulations 2008, or CPUT as the regulations are commonly known, which relate to unfair business-to-consumer commercial practices. CPUT have formed the basis of numerous enforcement actions, both criminal and civil, by local authorities and national regulators in a variety of sectors over the years, and they continue to play a key part in consumer protection in the UK. As many of you will recall, CPUT implemented the EU Unfair Commercial Practices Directive 2005, so the regulations are therefore retained EU law under the EU Withdrawal Act 2018, but they'll soon migrate into domestic primary legislation through the Digital Markets Competition and Consumers Bill. Whilst we'll touch on these changes, the focus of this talk is going to be to provide an overview of the relevant requirements under CPUT and the key case law that seeks to interpret these. Fred will start by telling us about the commercial practices that are considered unfair under CPUT and the manner in which these are enforced. I'll then go through some of the key case law, and Fred will conclude with his thoughts on the future of regulation of unfair commercial practices.
Thank you, Anna. In 1962, the Maloney Commission report dealt with the defective nature of the Mercantile Marking Acts of the 1800s. In 1968, the Trade Descriptions Act came into force, and for the next 50 years, that formed the backbone of consumer protection. There were some areas which were not necessarily carved out, but had their own provisions for consumer protection, in particular food with misleading indications as to the nature of the food, and consumer credit with misleading advertisements as regards credit. But the backbone, as I say, was the Trade Descriptions Act 1968. In 2008, the United Kingdom had to implement the directive to which Anna has already referred. This was not contentious because there was no alternative. However, it's useful to consider what was said at the time about it. One looks at the directive and recital 12, harmonisation will considerably increase legal certainty for both consumers and business. Both consumers and business will be able to rely on a single regulatory framework based on clearly defined legal concepts. This was taken up, of course, by the government, who heralded it as something really good and new. Trade Descriptions Act, 50 years of case law, put it to one side. It cuts red tape and puts in place a simpler and clearer consumer law that will be easier to implement and enforce. Professor Howes, in European Fair Trading Law, said, "The problem of uncertainty related to the extensive use of general clauses is made much more serious because of two other features. First, the broad, vague and unclear scope of the directive makes it very difficult to foresee the possible effects of the general clause. Secondly, the problem is made more serious as a result of the maximum character of the directive. The directive can, in a very surprising way, like a jack-in-the-box, affect both detailed and general legislation and case law of member states." And in 2008, that's what we got. Just to illustrate how clearer and simpler it all is, when one goes to the categorisation of unfair commercial practices in our 2008 regulations, and for example misleading actions, which I'll briefly come to, one sees that there is a subdivision into three areas of factors, one might call them, in total 37. The basic prohibitions are 5 in total. One goes on top of that to what is currently Schedule 1 of the 2008 regulations, which are banned practices, totalling 31. Section 1 of the Trade Descriptions Act had about 6 lines. It worked quite well. An overview then. Regulation 3 describes what is prohibited. That will, if the bill stays in its current form, become Section 218. Now it's Clause 218. One goes to Regulation 5, which will become Section 219, with the bill in its significantly unchanged form, which is likely, which relates to misleading actions. And there is a slide on this. Basically, the alleged offence is giving information which is false and therefore untruthful, or the overall presentation deceives or is likely to deceive the average consumer, subject to the effect of the rules, or concerning the marketing of the product, and it causes or is likely to cause the average consumer to take a transactional decision he would not have taken otherwise, taking account of its factual context and all of its features and circumstances, and the informational presentation is in relation to any of the matters listed in Regulation 5 brackets 4 brackets, and it causes or is likely to cause the average consumer to take a transactional decision he would not have taken otherwise. Clear. What was the wording? Cuts the red tape. Simpler and clearer consumer law. One goes on to misleading omissions. Again, there's a slide on this under Regulation 6, which is currently Clause 220 in the bill. A misleading omission is something which, in its factual context, taking into account Regulation 6.2 matters, omits material information or hides material information or provides material information which is unclear or fails to identify commercial intent unless apparent, and as a result it causes or is likely to cause the average consumer, etc., etc. Then one goes to Regulation 6, which will become Section 221 of aggressive commercial practices. Regulation 7, dealing with professional diligence, to become Section 222. And then there is Schedule 1 in the current legislation, Schedule 18 in the bill, cross-referring back to Regulation 34D, which relates to professional diligence. And then we have the schedule where all the 31 areas are outlined. This is underpinned originally purely by criminal offences, mirroring in some extent the general way in which the UK legislates and did so under the Trade Descriptions Act 1968, with penalties, with the matters being triable in England and Wales, either in the Magistrates' Court or in the Crown Court, with fines now effectively unlimited and imprisonment. In addition, we have Regulation 27A, which is Clause 225 in the bill, being matters which relate to redress, i.e. introducing civil remedies, but that applies only to misleading actions and aggressive commercial practices. Back to Anna, please.
The concepts used in CPUT, such as commercial practice, trader and transactional decision, are all defined very broadly and have been interpreted by the courts in line with the consumer protection objective of the legislation. So, for instance, the courts have confirmed that a commercial practice doesn't need to be something that the trader does generally, but can relate to a single act, such as an individual advertisement, as in the UPC case in the CJEU. This is consistent with the Court of Appeal decision in X Limited, which concerned the circumstances of a single sale of CCTV equipment to an elderly customer who had been misled into believing that burglaries in his area had risen by over 46%. We also know from the Court of Appeal case of Scottish and Southern that there can be more than one trader in relation to the same activity, which means, of course, that more than one trader can be prosecuted for an offence under CPUT, as was the case in Scottish and Southern. The breadth of the concepts under CPUT is also clear from the court's approach to the term transactional decision, which Fred has spoken about. and it does not require a consumer to part with their money or enter into a binding contract. According to the European Court in the Trento case, it can include the act of simply walking into a shop, or by analogy perhaps a consumer clicking on a link on a website. The breadth of these concepts is counterbalanced somewhat by the definition of the average consumer, who CPUT tells us is someone who's reasonably well informed, reasonably observant and circumspect. In the case of OFT and Purely Creative in the High Court, Justice Briggs explained that the UCPD, or CPUT, were there to protect consumers who take reasonable care of themselves, rather than the ignorant, the careless, or the overly hasty consumer. I'll now hand over to Fred, who'll talk about the way forward.
The way forward is already clear, and that is the DMCC bill. There would have been an opportunity since Brexit to go back to the Trade Descriptions Act or something similar, but on the one hand that would reintroduce the simplicity of that act and also reintroduce all the cases which over the years delineated what was a false trade description, not least of all cases such as Tesco and Natras in the House of Lords. However, on balance, it was thought, perhaps not on balance, that would be retrograde, and having lived with CPUT now since 2008, with a body of case law, not only UK but also the ECJ, which requires to be followed historically but not in the future. Nevertheless, we all know the rules about that. It would be counterproductive to return to the old legislation. It should be noted that the new legislation, as it will become under the bill, is very similar to the 2008 regulations. Little has changed. It is merely a matter of tidying up certain aspects. In my view, none of the cases, those to which Anna has referred in particular, will in any way be affected by the slight change in wording of the new bill, and therefore the current body of case law, both European and UK, will remain to be highly relevant to the Act as it will become and the clauses to which I have referred. Thank you very much, everyone. I hope that's been some use.
Thank you.